Morning, ladies and gentlemen. Highly appreciate for organizers' effort and hospitality to make this conference happen. It's my pleasure to present my work on AI for predicting patentability and address legal intention from my university, National University of Science and Technology, for future cooperation with you all for both academic projects with commercial interest. As you can see, we are already friendly with many Asian universities, IP codes, IP offices, and industry for practical projects, which make our teaching research truly useful for the real world. However, we wish to establish friendship and cooperation in Europe in the future with you all. My name is Mei-Hsin Wang. I'm a fellow Royal Society of Chemistry UK, PhD from Imperial College London, and LLM from Suzhou University, adjunct teaching in few universities, research institutes focus on patent monetization. Dr. Che Huizhong is my research partner. We have worked on several projects, how artificial intelligence, machine learning, blockchain, etc., and this modern technology apply on predicting patentability. Therefore, based on patentability to predict company stock value, of course, it further involves analyze patent quality and value based on several patent factors. In this slide, you can see the pictures of my university in Taiwan, which is the place where I'm from. In this slide, we present some global ranking of my university to enhance your confidence. If you are interested to convince your university for MOU with my university, because if we have MOU between our organizations, it will be easier to apply government or university funding for future cooperation, bring you to Asia, not limited to Taiwan. Emerging technology does change the whole intellectual property ecosystem and make everyone who is interested to participate. A patent can be monetized in many ways: sales, licensing for royalty, litigation, tokenization as virtual currency, etc. Modern technology can be applied to enhance the performance, value and quality of the patent and support risk management. For example, patent litigation or patent invalidation re-examination. In today's research, which I'm going to present to you, it's similar to US AIA. It happened after patent was granted. If the patent involve high market value, your competitors certainly would try all effort to destroy your patent. In this case, patent insurance, patent-based lending, patent-backed securitization could be involved to raise funding for provide securities in order to prevent a loss. Last month in CICO Poznan, many audience asked whether the new technology will be too difficult for us in legal profession. Actually, we only need to use the tool, and there are many commercialized tools available for us. Simply a few clicks to generate the data we need. Nevertheless, the charts table produced automatically for us. Therefore, we humans use our brain intelligence and understanding to interpret the meaning of the information generalized by big data analysis tool and finally make comments and decisions. Basically, inside the machine or platform, it covers lots of the data. Of course, loading data, cleaning and adjusting data, text or chart analysis, and finally, charts table and list for us human. We human need not worry about data extraction of multiple analytics or technique, as they are the models built inside for us. Of course, there are logics and behind the scenes, such as different terms to define the research. For example, identical, phonetically, identical, or one letter or more, or difference, with prefix, infix, or suffix, etc. We also need not worry too much, as we are well capable enough to comprehend those logics. Just few clicks and typing, it will generate the outcome for you in seconds or minutes. As you can see, the parallel case, they look similar but different, right? Without AI, machine learning, I don't think human can find those the potential infringer by hands, because they could be anywhere in the world. Or the fruit of the loan case, text with images. Even in a court, judges apply the modern technology as well. You may have heard the complementary function of EPO to evaluate patent value and quality already, performed by artificial intelligence. Of course, it requires some prior calculation based on defined parameter and indications. Again, as I mentioned, just few clicks or typing or dragging the images into the icons. Then you will get the search result worldwide with a well-organized table or charts and detailed information globally. If you wish to dig into particular competitors, you click again and you get what you want. For litigation worldwide, there are commercial tools available like .ip from Clarinet, which support your argument for courts or IP office. It's so convenient to support the good decisions and strategies for corporate organization and individuals as well. Not only patent trademark tools are also well developed, just to show you the modern tools that demonstrate various manner, allocation-wise, category-wise, and good presentation with artificial intelligence tools support our daily legal work, research, and teaching. I believe now you will agree there are huge change for artificial intelligence emerging technology. Therefore, our research and teaching must be different from now on to meet the real world situation. Otherwise, our students would not be able to cope with their daily practice. Patent is similar to the real asset. It's a legitimate right issued by the patent office. Therefore, we can sell, litigate, licensing, securitize, or for funding with specific purpose. So you see there are some big, huge deals for patent-rich corporates, not limited to pharmaceuticals, patent litigations, royalty securitizations. This is a tool called Patent Crawl, which we use to train students to search patent, predict analysis. And simple, just few keyword typing or image dragging, you get the outcomes without too much waiting before you can see your competitors worldwide. And Patent Crawl, artificial intelligence, machine learning can expand language and correlations for categories, corporations, and also technologies. And they could provide you the patent landscape with hundreds of charts. Now, more than enough to produce academic papers and many information review to support the strategy and patent management with commercial economy values. And the profile for this Korean case, as we can see, the patent quality was a very good profile. However, we notice the patent values still have a lot of room to be improved. Therefore, we can give this report, give this list to industry, to commercialization, and we can further study their patent sustainability, produce papers. So with industry, there's no conflict at all. And if we click particular parts, we we will gain all these list of all the pattern, or we can export the charts with all necessary index on them by machine learning tools. We can do further analysis to generate academic paper. Of course, we do conduct the data mining, statistics confirmation, big data, machine learning for predicting patentability, then analyze through our brain. For patent, it could be pledged or patent could be licensed. They must be value higher. So what we did is we get the invention, claim, construction, prior arts. So the strong prior art form, they could challenge patent claims. Potential limitations of the claim construction would reveal. We can suggest industry what they can do, or they can find their way to purchase more patents, or to support their patent portfolio, or they could just settle with the defender or plaintiff, whatever. So the decision making for patent transaction, license, and asserting that human value maintains. Of course, now we all agree patentability is crucial. Competitors attack each other for economic monopoly. It's effective to wipe out competitor by destroying their patentability. As I say, we in this research we try the China invention patent. Last month in CICL, we actually tested those utility model patent, but for more than 21,000 patent cases. But this time we use invention patent. It was which had been previous filed re-examination proceedings from 2000 to 2021. And we train the model first. We predict the test comparing to the existing invalidation re-examination decisions in China. So machine learning and prediction text all compared to the existing answer of the invalidation re-examination decisions. Again, we use ANOVA to confirm the significance of patent indicator. And SVM is the beta model we choose to find it appropriate to predict the patentability. So this analysis, we have 8,666 cases of invention patent, which have been filed in validation re-examination proceedings in China for the past 21 years. Of course, we grading them into two groups. One is they survived partially or fully. The other group is they failed. So there will be group 0 with all invalid patents. And in the case, we can see we have 3,642 cases which belong to group 1 and 1,1661 cases in group 1 which will fail the re-examination proceedings. Nevertheless, in this case, in this design, we further divided this group 1 and group 0 based on where these invalidation re-examination proceedings were filed. So they were further divided into 13 application regions. Then we can compare in China whether the more developed area and the less developed area will have a difference, or will this regional difference will impact the decision's successful rate. So here we can see the based on these 13 regions, the group 1 successful case and failure cases distribution. And in invention pattern, we only found 3 significant pattern parameters, which are the number of attached figures, the number of words in the abstract, and the examination durations. And for those 13 regions, we also have to confirm the significance. So we found US, Japan, Guangdong, Shenzhen, Jiangsu, Zhejiang, Beijing, Germany, Shanghai, and the other China, and the overseas applicants. These are the regions who file this invalidation re-examination procedure with significance. So we only choose 11 regions for the further analysis. For model training, as you can see, SVM looks quite presentable with a reasonable outcome among 13 regions. For the training outcomes, again, the group 1 with a partially or fully successful survive these invalidation re-examination decisions patterns. They show the good accuracy for training. For predicting as well, for testing as well, is again the group 1, the pattern claims with all or partially valid, they shows the better outcome. It's reasonable because the successful pattern, good patterns, they have their patterns, the parameters, characters, criteria, which we can identify whether they valid, whether they are better. But for the weaker pattern, they could have many weaknesses in different areas, so they are less possible to be trained. So the number-wise, percentage-wise, group 1, the pattern with valid patterns. When we apply the SVM model with the RBF kernel, the training for 20 years, testing for 1 year, the outcome performed pretty well. Training outcomes 98%, 0.5. And the testing outcome is 95%, 96%. That prove our method, our model is workable. So again, we agree is the AI big data support pattern monetization, in particular for how we can predict the patentability, sustainability. So we can search the file wrapper assistance with validity issues through the pattern crawl. The validity function could offer semantic prior art search, and they could support us to claims charts creation for invalidation and supplement argument with prior art references existence. So the actionable pattern intelligence, true pattern quality, unlimited design possibility were offered by AI, big data mining, and machine learning for IP. So this is my presentation today. Should you have any questions, I would be love to answer you. If you need any training or any discussions later, please do not hesitate to contact me. My contact information is shown here. If you need to have more detail, you can read our books. Of course, we'll have more coming paper publication and books published as well. So thank you very much again for the organization and for the audience. Thank you for your patience.